Thank you for inviting me to talk at your conference. I'm sorry I can't be there. The topic that I've been asked to talk on is the Royal Prerogative of Mercy, using the Katherine Folbigg case as an example. It's a case that reveals how the Royal Prerogative can still work reasonably effectively, and it also, more importantly, reveals how errors can and are made in a trial. In her case, there was a multiplicity of errors, starting in about 1999 and running through into 2018-19, a continuum involving a police investigation that was deeply flawed, a trial that focused more on circumstantial evidence than it should have, and on aspects of the evidence which were not properly factually based. It ran on to a number of appeals, which, in my opinion, should have been successful, or at least some of them, and then to a inquiry that was called by the Attorney General of New South Wales after a petition to the Governor. The delay in calling that petition was lengthy. The inquiry that was held came to a conclusion that did not assist Ms. Folbigg, and from there we determined to just seek a pardon from the Governor rather than another inquiry. But ultimately another inquiry was held, and the Commissioner of that inquiry, former Chief Justice Bathurst, found that there was a reasonable doubt as to her guilt, and that was sufficient to firstly get her pardoned, and then for the Court of Criminal Appeal in New South Wales on 14 December 2023 to acquit her of all counts, and their task ended, and there's still an ongoing process about how the state properly deals with compensation for her for the many failures that occurred. If I can start first by going to some of the facts of the case, and they're particularly significant in that she was charged with the murder of 4 of her children. The first one was Caleb, who was born on the 1st of February 1989 and who died on the 20th of February 1989. He was 19 days old, and his death was put down to sudden infant death syndrome, there being no identifiable unnatural causes of death. That is, there were no indications that he had been harmed in any way by his mother or anyone else who may have been caring for him. Kathleen then had another child, Patrick, who was born on the 3rd of June 1990 and who died on 13 February 1991. He was aged 8 months and 10 days. He had had problems with epilepsy, and his cause of death was recorded as asphyxia due to airway obstruction 1 hour and epileptic fits for 4 months. There was no indication that he had been harmed by Katherine Folbigg or anyone else who may have had him in care. The third child was Sarah, who was born on the 14th of October 1992, and he died on the 30th of August 1993. She was aged 10 months and 16 days. Her death was put down to sudden infant death syndrome, there being no identifiable unnatural causes of death, and there that matter should have ended. Subsequently, at the final inquiry, evidence was brought forward that showed that there was a genetic variant that Sarah had, which was a CAM2 variant, which most likely contributed to her death. The fourth child was Laura Folbigg, who was born on 7 August 1997 and died on 1 March 1999. She was 18 months and 22 days old. Strikingly, in her case, there was available a natural cause of death, which was myocarditis. Unfortunately, for Katherine Folbigg, her cause of death was not recorded as myocarditis. There was no unnatural causes of death identified, and the person who did the autopsy was heavily influenced by the notorious Meadows Law that, briefly summed up, claimed that one death was sad, tragic. The second death, any second death in a family, was suspicious, and a third death was homicide unless proven otherwise. That extraordinary proposition influenced the Katherine Folbigg trial in a devastating way for her, and has since been roundly condemned as basically wrong and quite atrocious. But one of the most important factors in this case was, if you go back to basics, you need some evidence that might make out the elements of murder. In such a case, you need factual matters that the Crown can prove, going to the elements of the offence of murder that need to be proven beyond reasonable doubt. And what seemed to have been forgotten in this case was that a fact is a thing that can be proven to be true. And one of the matters that needed to be proven was that these children died intentionally at the hands of Katherine Folbigg. So you would normally think that you would need some evidence that she harmed them in some way. And they didn't have any evidence that she harmed any of her children, but the Crown advanced at trial that she smothered each of the children, and they based the proposition that she smothered them on the possibility that a child, or anyone for that matter, can be smothered without leaving any signs or evidence that they were indeed smothered. So, having no evidence that they were smothered, the Crown raised the proposition that we don't need evidence that they were smothered. We simply need to have an absence of evidence, because smothering can leave no signs. That's the first problem with the case at trial, the lack of evidence, the lack of any facts that can show that she harmed the children. Going back a step from there was a police investigation which commenced upon the death, the day of the death, indeed, of Laura Folbigg. That inquiry conducted by the police involved, in large part, seeking out the experts that they could find who supported the Meadows Law proposition. That is, you can't have 3 natural deaths in a family. In this case, there were 4. So, obviously, the claim was that this was so exceptional that she must be the murderer. So they sought out experts, and you'll see in the paper I prepared for you who they were. They were the police, or one police officer in particular, took a trip to England to find an expert, and a trip to the United States to find another who could give evidence that you can't have 3 or 4 deaths in a family of natural causes. So the process took some time, the police investigation, and it wasn't that the prosecution was unaware of the difficulties in advancing a case without evidence. And I'll come to some further evidence that was highly speculative and therefore not properly factually based. But before the trial commenced, on 2nd of February 2001, the Office of the Director of Public Prosecutions in Newcastle, New South Wales, advised the Detective Senior Constable in charge of the investigation that the matter should be referred to the State Coroner in order for a full inquest to be held. Now, if an inquest had been held, evidence could have been brought about how the children may have died, and the matter dealt in an ordinary way without the drama of a criminal trial. Instead of holding a full inquest as requested, an acting State Coroner advised on the 2nd of April 2001, 2 months after receiving the advice from the Officer Director of Public Prosecutions, that Katherine Folbigg should be charged with murder. No full inquest had been held, and it's uncertain, at this time anyway, what documents the acting state coroner was relying upon in order to recommend murder without receiving evidence that could have been brought. So, and again on the 6th of April, that state coroner met with a Crown prosecutor and the detective in charge of the case, and they resolved that Katherine Folbigg should be charged with murder. There commenced a series of events that were horrifying for Katherine Folbigg and displayed most clearly how the state of New South Wales dramatically failed this woman. Initially, bail was even refused when she was arrested, and she, a person of good character who had never neglected her children, was put into an environment totally unknown to her and treated in a way that must have been and was terrifying. In any event, eventually she was granted bail, and on 24 May 2002, she appeared for committal and was committed for trial. That was a committal conducted on the papers. The system had commenced to change in terms of committals, at least in New South Wales, so that careful consideration of what evidence the prosecution had to bring charges as serious as these dealt with in a relatively straightforward way without the hearing of evidence. Now, of course, there effectively aren't committals in New South Wales, and matters just proceed through to prosecution. So one of the most crucial steps in the prosecution of Katherine Folbigg was the joining of the trials, that is, all four cases the prosecution wanted to have run together. And an application was made on the 22nd of November 2002 by the defence team to have the trial separated. But the prosecution claimed that coincidence evidence, that is, two or more events or matters, was so important that it couldn't simply be a coincidence. Strangely, in a number of instances, one of those events put forward was that she was the mother of the deceased, and in three of the incidents was there when they were found, the children found to be dead. That was regarded as not coincidence. So the trials could be joined, and there was also a tendency one which involved anger, which was not pressed terribly hard at trial, but along with coincidence evidence was sufficiently strong to, they claimed, the judge claimed, to allow the trials to advance together. What people tend to forget about tendency evidence in particular is that it starts as a rule of exclusion. Now it has grown into a just about anything can get in, and showing a tendency that the person had to do something, a state of mind or a conduct which the jury can use to determine if they committed the actual offence or offences charged. But it's an exclusory rule, and you need significant probative value. That's often forgotten, and what you get is an invitation to a jury to speculate, and you can get in, and it happened in the Folbigg case, evidence which was not probative, ordinary, everyday, but can be regarded as damaging if taken out of appropriate context, and I'll come to that a little bit more. But in any event, the trials were joined because without that, the prosecution had no case. And what they needed to bring was the 4 deaths and the claimed exceptional nature of those deaths. And that was what the jury heard, along with another charge involving Patrick Folbigg, which was a claim that on the 14th of October 1990, Katherine Folbigg maliciously inflicted grievous bodily harm upon him, which ultimately led to his epilepsy, so the claim seems to be, and that ultimately led to his death, because they had no evidence, of course, that she harmed him at all, but without the grievous bodily harm charge, which came as an ex officio indictment, they couldn't prove that she was involved in his murder, which came in February 1991, they claimed. So they needed to have a grievous bodily harm, which caused an injury, which ultimately caused epilepsy, which may have ultimately led to his death, or his smothering, or whatever you like. Have your choice, I think was the way it seemed to proceed. But the claim advanced by the prosecution was that there was no possibility of natural causes of death. And there's a particular address that the prosecution gave to the jury, which, in my opinion, reversed the onus of proof and caused one of the most grievous miscarriages of justice in Australian history. In his closing address to the jury on 13 May 2003, Mark Tedeschi the Crown Prosecutor did something which I regard as unusual and over the top. And I've referred to it in my first petition to the Governor for an inquiry, and it's been referred to a number of times by a number of people. It's an address to the jury which, in my opinion, has a tendency to inflame, and it also is an address which is simply wrong, factually wrong. He said this: Caleb may have died from a floppy larynx or SIDS. Patrick may have had an ALT, which was a first epileptic attack or encephalitis. His death may have been caused by an epileptic attack, an epileptic seizure. Sarah may have had a displaced uvula or SIDS. Laura may have died of myocarditis. Well, yes, ladies and gentlemen, I can't disprove any of that. But one day some piglets might be born from a sow, and these piglets might come out of the sow with wings on their back, and the next morning Farmer Joe might look out the kitchen window and see these piglets flying out of his farm. I can't disprove that either. I can't disprove that one day some piglets might be born with wings and that they might fly. Is that a reasonable doubt? No. Is a hypothesis that the defence advances a reasonable doubt? No. Why not? Because if you look at what they are suggesting, not in isolation but in totality, there has never ever been before in the history of medicine that our experts have been able to find any case like this. It is preposterous. It is not a reasonable doubt. It is a fantasy, and of course the Crown does not have to disprove a fanciful idea. Now, those are the words of the Crown Prosecutor. They're amazing in a number of ways. First of all, the Crown Prosecutor is acknowledging that he can't disprove the defence case. That is, that there is a reasonable doubt. He's simply saying what was later found to be correct as to causes of death, that those causes are fanciful. They weren't at the time of the trial, and his address indeed suggests that there should be a reasonable doubt found by the jury. But he couches it in inflammatory language. He puts it in terms of pigs and piglets, and that's not the way a Crown, in my opinion, should be addressing a jury over an important issue as to the manner and cause of the death of children. In any case, anywhere in Australia, such an address, in my opinion, should not occur. The other thing that the address does is attempt to reverse the onus of proof. It attempts to say that the defence has to come up with causes of death. The defence did not have to. They did, but they did not have to. The Crown had to prove the cause of death and who caused the death, if anyone. In this case, they couldn't do it. And what's a way around that? Suggest that the ideas put forward by respected forensic pathologists and others, that they're fanciful, and suggest that you've never seen so many children die in the one family. Later proven to be wrong, factually wrong, outrageously wrong. And that type of address, which simply inflames, does nothing to bring respect to the legal system, of which all lawyers belong. It's important that we maintain a respect for the law. That wasn't the only inflammatory part of the address. I've said some words about coincidence and tendency evidence. But strikingly, that was used by the Crown Prosecutor as not just to bring the trials together, but also he used language about certain instances of the conduct of Katherine Folbigg, which were also designed to ridicule and inflame and suggest guilt. And one thing he suggested, which he said involved coincidence, that is, not a coincidence, a sign of guilt, and was, in my opinion, inflammatory, was this. And he said it in a way that really should not have been said. God, her going to the toilet was very dangerous for these children. 3 out of her 5 children had incidents when she happened to go to the toilet. God, you'd be locking up the toilet, wouldn't you? Every one of them was during a normal check of their well-being. Gosh, you'll be telling her not to check them, wouldn't you? What amazing coincidence. Or is it? First of all, that is just not factually correct. Indeed, she, that is Mrs. Folbigg, only found Caleb and Sarah deceased at night. And it's not a coincidence that she happened to be going to the toilet. When she got up at night, she would check on the children. This is not a small matter, because there are dozens of them throughout the trial. When this type of inflammatory rhetoric gets into a trial, and where people are ridiculed and suggested that they're doing wrong to someone by their conduct, normal conduct, that is unacceptable. It must be found to be unacceptable by all right-thinking lawyers. This is not a simple case of just 1 or 2 minor rhetorical flourishes in a case designed to attract the attention of a jury. It's a case where there are continual suggestions of wrongdoing out of ordinary, everyday activities. Ordinary, everyday activities involve looking after babies. And what is most unfortunate is that judges later found all of this to be acceptable, found it acceptable that coincidence evidence should be used, found it acceptable that tendency evidence could be used, found it acceptable to say that the ordinary expressions of frustration and anger by a mother showed guilt, or could be used to find guilt in a person. None of that was, in my opinion, appropriate. But we all need to reflect that when we're using an adversarial system, we should be careful about the language we use, because there are 12 people sitting in judgment on someone and they don't need to be inflamed. It should have never been suggested that 3 children or 4 children couldn't die of natural causes in the one family. It should have never been acceptable that the reasoning behind that type of argument was never put forward to the jury. It should have never been acceptable that Sir Roy Meadows should have been not disclosed to the jury. What comes right back to the trials never should have been joined on the use of tendency and coincidence evidence. It is a way of short-circuiting. It's a way of allowing prosecution to bring forward things that do not properly relate to the facts in a particular case. Times have changed. I'm aware of that. Since 1995, tendency and coincidence evidence has become the flavour of the day. But it is not good law to apply it, in my opinion. But it is the law that judges can admit it into evidence. They ought to be careful when they do that. And politicians who introduce this type of defective, potentially grossly defective law, they should be ashamed of doing that and forcing it into a legal system. When first looking at this case, I approached a leading forensic pathologist in Melbourne called Professor Cavanagh. He did a very extensive report for the first petition, gave evidence at the first inquiry, and has had an ongoing role in the case. He, along with 10 other pathologists, and also a series of pathologists in Australia, in Canada, in England, have been involved for the defence in this case. But I think that probably Professor Cavanagh's first report states clearly what the ultimate outcome was and what it should always have been. Remembering that a forensic pathologist who did the final autopsy on Laura Folbigg put undetermined as the cause of death because he thought he had to put that rather than myocarditis, because there'd been 3 other deaths in the family. And you can't have natural causes where you have more than 2 deaths in a family. You need to keep that in mind. It's an absurd, ridiculous, dangerous, nonsensical dogma that was absolutely accepted in Australia, in England and other places. It was based on nothing, no reality whatsoever. Anyway, Professor Cavanagh's report, which we used to help at the first inquiry, I read from it, just a short bit from it. If the convictions in this case are to stand, I want to clearly state there is no pathological or medical basis for concluding homicide. The findings are perfectly compatible with natural causes. The findings cannot rule out smothering in one or more of the cases, but especially in the case of Laura, Not only is there an acceptable natural cause of death easily visible, it is important that absolutely no signs of asphyxia or compression of the face are present. I repeat just one part of that again. The findings, that is the findings at autopsy on all the children, are perfectly compatible with natural causes. The case should have never been brought to trial. The case should have been treated as a coronial matter and assistance given to the mother. Instead, the mother was tortured, effectively tortured, in jail for 20 years. I use torture in this way. Strip searched, locked in isolation, liberty deprived for 20 years. Keep it in mind. That's not a light infliction of pain. I suggest that it's also has happened, and I refer to a number of cases in my written paper, including cases in South Australia and the Northern Territory, and that type of infliction of pain should never occur in Australia using what should be a good criminal justice system. But where the system gets flooded by dogmas, gets bent out of shape by suspicion and speculation, you will get these miscarriages of justice. And it's simply not acceptable. If anyone finds it acceptable, who's a lawyer, they should give up their profession. A large part of the prosecution case against Katherine Folbigg relied upon the use of some of her diaries and journal entries. Not all of them, just some of them. And these journals and diaries were used by her to record everyday events, but also the journal entries were used to relieve stress, I suppose, because from a young age, Katherine Folbigg was advised by a psychologist that she could use journals to record her feelings and emotions, and that was regarded as helpful when dealing with grief, when dealing with problems in life and the like. That was used against her. Her husband, who was once her greatest supporter, split with her prior to the trial, and that split involved him firstly handing over some of her journals. They had separated. She had left some journals behind. He handed those over to the police. She was unconcerned about the content of the journals because, quite simply, they contained no confessions. No confessions at all. That is, let me be clear about this. A confession is where somebody says, I did this or that to something or someone. An admission is something different. It's a representation against interest, and it can be just about anything. And the prosecution introduced the journals as admissions of guilt. Indeed, they were admissions of guilt because she felt guilty about the deaths of her children, but not in a way that suggests that she actually harmed any of them. So the nonsense proposition was that she wrote words in her diaries which showed that she harmed them. Again, I repeat, not one word said, I hurt Caleb, I hit Caleb, I smothered Caleb, I hit Patrick, I smothered Patrick, I hit Sarah, I smothered Sarah, I hit Laura, I smothered Laura. There was none of that, none of it. There was a guilt in it, guilt in the diaries of a grieving mother. And I think it can be shown through the evidence that we first brought before the Governor of New South Wales, in effect the Attorney General on the first petition. We tended to that Governor the report of Dr Shamila Betts, and she made it quite clear in her report that, and I'll read part of it because I think it's important. She said, "It is evident that Mrs Folbigg had unrealistic notions of the function of motherhood and no doubt placed considerable pressure on herself. Despite this, Mr Tedeschi's assertion that the Crown was able to read the truth behind the diary entries, which according to the Crown were tantamount to confessions, is misleading and unsupported by my reading of the diaries or the psychological literature on maternal adjustment in both bereaved and non-bereaved mothers." Now that was evidence that could have been considered by the Governor, and it was also evidence that could have been considered at the first inquiry, but it was not, because the first inquirer determined that he could work out what a grieving mother would feel. With greatest respect to the first inquirer, Mr Blanche. He's an old white man like me, and I doubted if either he or I could be fully acquainted with the emotions of a grieving mother. That said, he determined that he could do that. That was up to him. The lawyers at that inquiry, including me, had a different view, but he determined it. At the second inquiry, of course, a different view was taken, and a number of psychologists and psychiatrists gave evidence, gave reports to that inquiry. I read very briefly from one of the reports done by Professor Stevenson, and she says, "The only person who may be able to interpret the writings is the person who wrote them, and even they may not remember what they meant when they wrote them. They may have been in a highly emotional state. They may have been in a disassociated state. It may have been factual, but also may have been fantasy. They may have no memory of writing, so any interpretation is likely to be erroneous. From my experience and from my research, journal diaries should not be interpreted at all. They are not factual accounts. They are emotional musings, and only for the private use of the writer. The meaning one day could be different the next, or there could be no meaning at all." Other psychologists got to see Katherine Folbigg, including a psychiatrist called Kamal Tuma, who said that he could find no indications of criminal intent in any of the behaviour of Katherine Folbigg. In general terms, that's what he said. So did a number of others. I've listed them all in the paper I've written, and I advise you to look at that, what they said, and also to look at their reports on the inquiry website, that is the second inquiry website. So what evidence was there that Katherine Folbigg killed her children? What evidence from the diaries? In my opinion, none at all, but you can all go and look at them, and you can also consider what the psychiatrists and psychologists say about them in unison, without demur. Each one of them says the entries do not show that Katherine Folbigg harmed her children in any way. That evidence was not brought out at trial. It was not brought out properly at appeal. It was not brought out at the first inquiry. And it was only at the second inquiry when the inquirer, former Chief Justice Bathurst, decided that it was appropriate to look at that type of evidence. In my opinion, it should have never been admitted at trial, but it was. It shows another really striking example of how the legal system can fail when it lets in the musings of a grieving mother. Musings, writings that do not contain any confessions, but that are ambiguous, that can have multiple meanings, and that's used along with a combination of the trials, the use of Meadows law, to damn someone to 20 years in jail. And it seemed that, well, it didn't seem, it was a fact that there was no way out for Katherine Folbigg once the verdicts of guilty were entered. But with Caleb, the verdicts were entered on the 21st of May 2003. Interestingly, in the case of the firstborn, Caleb, the jury brought back a verdict of manslaughter, not murder. So obviously the jury determined that she could not or did not intentionally harm him. So the proposition at trial was that there were a variety of ways that this could have occurred. One of them was simply that she lost control, and that the child cried, something like that, and she suffocated the child to stop it crying, and thereby the child died. Well, if that happened with the first child, one might have thought that she would have learnt not to put anything over the mouth or the nose of the child, so it might stop breathing. But it was nonsense. It was a proposition for which there was no factual matters supporting. And in the end, as the case progressed, eventually it was acknowledged there was no evidence of smothering, but there was smothering was something that was consistent with the deaths. And it moved into a problem of definition. asphyxia was used with hypoxia, and all sorts of problems arose for a jury to consider. And in the paper I've prepared, I've put some detail about that for those who wish to read in detail how a trial can go so wrong and how experts can use language that is perhaps not understood by the jury, and be at cross purposes with their meaning and what a jury member may consider the meaning to be. Anyway, there were appeals, and in February 2005, the first appeal against convictions was dismissed. There was a special leave application to the High Court which failed. On 16 May 2007, the Court of Criminal Appeal granted an application for leave to reopen the appeal against convictions, but on 31 December 2007, the Court of Criminal Appeal dismissed the appeals against conviction. As I mentioned earlier, there was a petition for a pardon, the first inquiry having failed, and that was to the Governor of New South Wales. And that petition was made seeking an unconditional pardon on the 2nd of March 2021. And it was supported by, in the end, or endorsed in the end by, I think it was about 150 scientists of various types and medical practitioners. It was based upon research into the effect of a CARM2 G114R mutation. And the petition was signed by myself and the solicitor in the case, at that point, Rani Rego. The endorsement came from scientists around the world, and certainly got the significant support from the Academy of Science in Canberra. The evidence that they gathered was that both Sarah and Laura Folbigg had a mutation which Katherine Folbigg also had, which can lead to heart arrhythmia causing death. And that sparked it was raised initially in the first inquiry, but not properly and fully, or should I say not fully, investigated. So the petition that was submitted on 2nd of March 2021 relied very heavily on that, pointing out natural causes of death for those two children, although of course myocarditis always existed. In the case of Laura Folbigg, Sarah Folbigg could now be regarded as having a natural cause of death that could be identified. There was quite some considerable conflict. Some of it's detailed in the paper I have prepared for you. But in the end, what the petition for an unconditional pardon got was on the 18th of May 2022, the Governor, on the advice of the Attorney General, ordered a second inquiry. We didn't seek a second inquiry, but the Attorney General, Mr. Mark Speakman, considered that appropriate. And from there, the inquiry ran, and ultimately the hearings that were held resulted in His Honour Bathurst finding there was a reasonable doubt. And he gives a very detailed report. I've made some reference throughout the paper to the reasoning. Now, what is extraordinary in this case, apart from the absence of factual matters to support a finding of murder, are the incredible delays involved in getting an inquiry by the exercise of the review function to the prerogative of mercy available to a governor and, in this instance, the Attorney General. If you look at the delays involved, the longest period of delay was between the submission of the first petition in 2015 and the inquiry that occurred in 2018-19. The reason for the delay is unknown by at least me. There were two Attorney Generals involved, and it's my opinion there was no reason for the lengthy delays involved, but it's detailed for you. The second attempt was the unconditional pardon, and during that process it was about a year where we continually submitted reasons why that petition should be fully supported. As part of that, we were accused of delaying things by continually pointing out errors in the case. We thought it might be of assistance, but people often use excuses why they're not doing something, and it's, you know, one way is to blame the people who are trying to seek action for any delays. Of all the judges who considered the Folbigg case, only one of them has acknowledged that they made an error, and that judge was once a judge of the High Court, Michael Kirby. He came out in a foreword to a book called Wrongful Convictions, in which he stated that the outcomes were wrong and that he'd made a mistake. And that type of acknowledgement is very important but very rarely seen. There were a lot of judges involved, at least 17, who made a significant contribution to the Folbigg case in terms of ensuring that she spent 20 years in jail. Those types of mistakes will happen, and they happen in every state of Australia. They should be acknowledged by the judges who made them, and they should be acknowledged by the politicians who appointed those judges. That's not being done properly. It's very good that the Court of Criminal Appeal in New South Wales acquitted Katherine Folbigg. But it's not enough. It's not enough because she suffered torture in jail for 20 years. The politicians should say sorry. The judges, as Michael Kirby did, should say they are also sorry and acknowledge their mistakes, not hide behind the fact that they're a judge. And where lawyers make mistakes, they should also acknowledge those mistakes, because it's not a perfect system. But what is really annoying, incredibly annoying, is that this problem continues. It continues in every state and territory. There needs to be a better way than simply having a prerogative of mercy. There needs to be legislation put in place. There needs to be appropriate funding. There needs to be a review in cases that deserve a review. You shouldn't be relying upon pro bono work by people on an ad hoc basis in a desperate attempt to get those wrongly incarcerated out of jail. I suppose the most positive thing I can say about how the system treats people is that at least we don't hang them anymore. Thank you.